In this episode of the podcast, I want to take a look at planning issues that can crop up when either buying or selling a property. Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. What are the issues? What is the law around planning permission? And why is it very important when you're selling or when you're buying property? Planning has to be in order. So the starting point for planning permissions in Ireland is the Planning Act of 1963. You may have heard of houses being described as pre-63s. All the big red bricks there on the North Circular Road and the South Circular Road that would have been operating as bedsits and flats and apartments and so on down through the years before bedsits were done away with. They're all pre-63s, beautiful big 3-storey, 4-storey in some cases, red brick buildings. They're pre-63s. North Circular Road, South Circular Road, Phibsborough, places like that. So they don't require, never required planning permission because they predated the Planning Act. So the relevant Planning Act is the 1963 Act, and it became effective on the 1st of October 1964. That basically means that any development carried out after the 1st of October 1964 requires planning permission, unless it's exempt. Now, there is various exemptions, but by and large, the starting point and the default position would be that any development carried out after 1964 requires planning permission. An important thing to understand about that is, and you'll see this as well in conveyancing files, and you'll have estate agents telling you that, that was done 20 years ago, it doesn't make any difference, the local authority never prosecuted. If you're in breach of the planning laws, the local authority has a certain period of time within which to prosecute you. I think the maximum is up to 7 years. And you'll have estate agents telling you, for example, that because the local authority didn't take any steps, then you're home and hosed, you're in the clear. But you're not. All you're in the clear from is prosecution by the local authority. It doesn't mean you've planning permission. And you could run into difficulty later on if you seek planning permission with a view perhaps to selling your house, because if you look for retention permission, you may or may not get it. So you need to be careful there. Bottom line is, 1st of October 1964, any development after that requires planning permission unless it is exempt. And there's a definition then of development in a later act, I think it's the 2000 Planning Act. And development includes not just works carried out, but also includes change of use. That's important, because you could have a change of use, for example, of a house to an office or vice versa, or commercial to residential, or residential to commercial. So change of use requires planning permission as well, and change of use is one of the definitions, or is covered within the definition of development in the 2000 Act. When it comes then to exempted developments, a development may well be exempt. For example, a conservatory or a small porch to the front of the house, or a small porch to the rear, or even a little kitchen or kitchenette or something of that nature, change of the front door, change of the gate and stuff like that. But if you're buying a property, you're being told that is exempt, well then you are entitled to get a certificate of exemption from an architect or an engineer. So that would be an opinion from the vendor's architect or engineer, basically saying that the development that was carried out is exempt, and the basis of the exemption is X, Y, or Z. That's important. There's 3 vital questions then you need to be looking at, or your solicitor needs to be looking at and will be looking at when he or she is doing his job when it comes to a planning question. That is, has any development or works been carried out? Is there planning permission? And is there finally a certificate of compliance with planning permission? So those 3 questions are key. Was there development? Is there planning permission? Is there a certificate of compliance with planning permission? The same thing applies to the Building Control Act, in other words, building regulations, or the building bylaws. Building bylaws would have predated the building regulations, the Building Control Act of 1990. So you're looking for a certificate of compliance with building regulations or the appropriate bylaws at the time if development was carried out. The holy grail is, was there permission? If so, is there a certificate of compliance with both building regulations and planning permission. And when it comes down to the contract of employment, the contract for the sale of a house, there's a general condition 36 in the Standard Law Society, contract for the sale of a property. And that general condition 36 basically is a planning warranty. In other words, it warranties that all the planning is in order, that no development was carried out except what has been disclosed, and everything is in order. But that planning warranty is so wide and so all-encompassing that it's going to be modified or changed by way of a special condition. So the vendor or solicitor will draft a contract in a way that will modify that to a certain extent. The planning could still be in order and so on, but it's unusual to get a contract for the sale of a property with the general condition 36 dealing with planning not to be modified or changed in some way. Architects' certificates of compliance are important documents of title. They certify that the work has been carried out in accordance with the planning permission and in accordance with the building regulations. It's important that those certificates are issued by a competent surveyor or engineer or architect who has professional indemnity insurance, and the declaration or certificate that he or she will do will say how long they've been in practice and where they qualified and so on. It's not enough just for the vendor, for example, to give some sort of a declaration. That simply won't work, won't come up to snuff. So the three big questions then when it comes to the planning from a conveyancing perspective and from a conveyancing purchaser's perspective, and indeed from the purchaser's perspective: was there development? Was there planning permission? Is there a certificate of compliance? If that's the case, if all of those things are in order, fine. If there was no development, fine. If it's exempt, fine, give me a certificate. But that is the situation there in relation to planning. The planning permission in Ireland and building regulations as well.
Thanks a lot for listening, and don't forget to subscribe so that you won't miss an episode.